Good day. I'm on Not Legal Advice's channel, but I'm doing this anonymously, so you'll have to guess who it is. Good day. Where does a cow go for lunch? The cafeteria. Tell me what a YouTuber's favorite line is. Leave it in the comments below. A YouTuber became a doctor, and this surgery is brought to you by Blue Apron. And last but not least, from someone who follows Not Legal Advice, wherever he may be, and his name is spelled Giresch. And Not Legal Advice liked this one, so he's suggested that I do it. How many bodybuilders does it take to screw in a light bulb? 3. 1 to do it, and 2 to tell him, you look huge, dude. Huge. I'm going to go off to the side. I'm going to let Not Legal Advice take over from this point. Oh, hi there, everybody. Not Legal Advice here. Thank you, that anonymous gentleman, for giving me his hat. Do you notice I'm wearing the same hat that anonymous gentleman was wearing? Anyway, good morning. Not Legal Advice. Like, subscribe, share, comment, show people. You can even show them anonymously, as the gentleman indicated, whoever that gentleman was. So I'm going to briefly talk about, sorry for being late. I'm going to briefly talk about the election in a way, side way, more about Congress, GTii, MMTLP, and the CAT system, which I like, the CAT system, because there's a CAD system, which is architecture, I think. There's a CAT system, I think, for asset forfeitures, and there's a CAT system for us at FINRA, involving FINRA. So first, election. So, I see a lot of election discussions with regard to MMTLP. That's where it arises. I see a lot of people who suggest they're going to do things, don't do things, might be motivated by contributions or other things. So I have a very specific view on what I think needs to be done. I think, and some of this requires constitutional amendment, but I think it makes sense. I think, one, congressional terms are too short. They should not be 2 years. They should be 4 years, and there should be a term limit of 2. So you get 2 shots. The reason why it should be not 2 years is because those people basically are running for re-election from day one. Their terms are so short. And the second year is a complete washout. So I think it would be much more efficient, better for the country, better for them if they really had an interest in doing a job, to have longer terms, but have a term limit. So they only go 2 terms and then are out. I also think my view is to prevent corruption and to be able to impose harsher penalties, both, that they should be paid higher salaries. So all those people should get CEO executive salaries, but with much longer minimum sentences if they commit any kind of graft or corruption. So in my mind, it should be a minimum 10 years in the federal pen, minimum served. And if you take money, if you take a bribe, if you do anything underhanded. So that would be my change in the system. I would certainly like to be able to cap the amount of contributions, but the Supreme Court ruled that you can't do that. I would certainly also like if the election season itself was shortened. So as opposed to, we go over a year, well over a year, there might be a way that you could construct it so the election season was 6 months or less. If there's less time, there could be less money spent, and perhaps the issue of the election problems with the financing would go away or be somewhat limited. Anyway, I was motivated because I saw some reference to some congresswoman who purportedly was working in the interests of MMTLP, and I had my doubts. Second, GTii. So I've reached out to people in general, and I've gotten a lot of positive feedback from people that are similarly situated who are interested in getting rid of GTii management. And I've given a whole litany of reasons in the past why I think GTii management should go. I've also kept people apprised of Alpine, and I'm aware of all the litigation that's going on. So most recently, and by the way, so I asked people to reach out, and a lot of people have reached out, probably over 300 at this point in time, have reached out with similar interest in getting rid of management. And I welcome anybody else interested in getting rid of management based upon real issues with them that you see. Feel free to reach out to me, and we can communicate about that. In the meantime, while we're trying to get it together, on May 15th, despite a directive not to, the directors being David Reichman, Kathy Griffin, and I think Mr. Gilbert, sold approximately 90,000 shares on May 15th, as reflected in the filing. Again, put that in context, they're basically diluting and suppressing prices, doing what I think is a lackluster job at best. And recall that Borgers was the accountant for these guys, hired March of 2023, just prior to the downlisting, who themselves were just unlisted because Borgers just got kicked out, can't conduct business as of May of this year. Borgers was the accountant that David Reichman chose. And recall, David Reichman was both the CEO, CFO, and chief accounting officer of GTii. He hired Borgers, who got canned because they were a scam outfit. They just asked for an extension on the 10Q. They're still selling shares. Enough said. I've kind of gave a litany of many reasons. Just look at the 10K and what the amount of money that was spent in 2023, the amount of cash that was spent, the shares that were distributed to directors. You make your own call, but if you're interested, reach out to me. And I'm just keeping you current because about 90,000 shares were sold on May 15th. And again, they filed or asked for an extension on a 10Q. They had previously asked for an extension on a 10K. They had to get rid of their accountant, who they hired at a very odd time in light of the downlisting, and the person who did the hiring is a tax expert. So I'll let you think about that and come to your conclusions. But if you're interested, reach out to me. 3, MMTLP. So I've kept people apprised about the arbitration. I've made multiple recusal motions to get rid of one of the arbiter. That's a kind of a recusals, get rid of them. The last one I filed, which I did a video on about a week ago, I talked about the new things that I learned was that he didn't have an office as he indicated. He didn't have the expertise as he indicated, and I had sued him. Despite that, on Friday, the director denied the recusal request. So we are going forward with the arbitration unless something happens. Now, I'm preparing paperwork. I was doing that over the weekend. I was speaking to Busy Brands while I was doing that. Have some things I need to file, which I'm preparing and will be filing Monday. I mentioned there was a Supreme Court case about arbitration, and after having a little more time to kind of think about it, the name of the case, by the way, is Smith versus Spizzirri. It was decided by the U.S. Supreme Court on May 16th, so it's a brand new decision. And that case involved so what happened was it was an employment law case situation. The plaintiff sued in state court. The defendant removed it to federal court. In federal court, it was appropriate that the matter be arbitrated, so it was sent to arbitration. The federal court dismissed the case, even though someone had requested a stay. They appealed to the Ninth Circuit. That's where I am, by the way. Ninth Circuit agreed with the district court. They took it up to the Supreme Court, which decided that and said, if anybody in these situations, if anybody has an arbitration situation and a stay is requested, then it should be stayed. And the difference between the stay and the dismissal is when it's dismissed, the federal court really has no involvement in the case until there is a request to have an arbitration award confirmed, vacated, or modified. If it's stayed, then if there's problems in the underlying arbitration or shenanigans going on, you could still go back theoretically to the federal court and get them to intervene. So that's significant. So in my case, as it turns out, filed in state court, removed to federal court, sent to arbitration, case dismissed, even though I believe there was a stay request here also. So I've now asked that the director of FINRA stay this action to let me go to federal court to get the district court to give me an opinion based upon this new Supreme Court ruling. But if this Supreme Court ruling applies to arbitrations and applies to FINRA arbitrations, and we don't know that yet, then it will give investors an additional tool. Because if, in fact, an arbitration is being had and it's being done improperly, not giving proper process or fairness to people like you and I, then you could go into federal court and seek the intervention of the court to have the arbitration corrected or vacated. Or the other part is, will they lose the right to arbitrate and you'll get a direct case in the federal court? Don't know. But the ruling does give the plaintiff more room in arbitrations, and it was a unanimous result, 9-0. So the Supreme Court in total agreed. And it also came from the Ninth Circuit, where I am. So I don't know, but I made a motion, which will be filed Monday. And at some point in time, I'm going to be arguing this case either in district court or Ninth Circuit. Ninth Circuit got reversed, so it'll be interesting to see how this goes. But I think it's a nice step and a little help for plaintiffs, like all of us are. And last but not least, the CAT system. So the CAT system is the Consolidated Audit Trail System. It's reflected in the new rules in FINRA Rule 6800. Has a whole bunch of requirements, reporting or record-keeping requirements in Rule 6830, whole bunch of stuff regarding what you have to keep, the nature of the transaction, the routing, etc. There's literally many, many items of information that are required. That's all good, but we don't know. The question is, because we've seen all the rules, a lot of the time the rules are not the problem. It's the enforcement of the rules that's the problem. And I'm not particularly, I don't believe in the credibility to this point in time of FINRA, the SEC. I don't believe necessarily that they're acting in good faith or that they will carry out and enforce the rules that they employ. And then on top of that, what kind of penalty is going to be enforced? Is it just going to be, again, another monetary penalty, or is it going to be a suspension? And I really think that the change has to come, because if in fact these agencies want to regulate and protect consumers, a fine does not protect consumers. A suspension protects consumers. So whether it's a suspension of the individual actors at a firm who do it, or if it's repeated, an actual suspension of the firm, that is much preferred over a fine, because the suspension will change conduct. A fine, we can see this. Fines do diddly squat, cost of doing business. But if you put the leading broker at a firm on the sidelines for a week, for a month, for 6 months, it's going to impact not only them, but the whole industry. And that's got to be a change. So contact whoever you can, any of your representatives. That would be good legislation to impose if in fact there could be mandatory penalties imposed for violations. that are outside the hands of FINRA and the SEC, because we really can't trust them to either enforce or properly penalize their members. And Alpine, if you look historically, Alpine, again, is the poster child for that. Historically, over 44 years, literally thousands and thousands of various types of violations, ongoing and permitted by FINRA and the SEC with knowledge. Anyway, just a quick little video today. Hope you enjoyed my part. Hope the gentleman who started it didn't bother you too much. Hope everybody stays well. And again, on GTii, anybody wants to reach out, reach out. Have a great day. Be well. Enjoy your weekend. And